What if the products contained a disclaimer? Does the manufacturer still have a duty to warn?
Under California law, the manufacturer or any company in the chain of commerce does have a duty to warn about foreseeable harms that product can cause. Some products are inherently dangerous, and warnings are essential to those types of products to alert the consumer that in using this product there's a risk of a certain harm. So even though a product might already be dangerous and the reasonable consumer might expect that product to be dangerous, the manufacturer or any company in the chain of commerce still has a duty to warn the consumer about those foreseeable or known risk. In addition to that, these companies and any other company in the chain of custody can't just rely on what they believe the product should be used for. They have to warn and guard against what we call foreseeable misuses of a product. Oftentimes, a company says that our product should only be used in this certain way and this way only. But the law says that the company doesn't get to decide that, and that it has to think about what people might do, what normal, average, reasonable people might do with their product once they buy it. And if that company or any other company in the chain of commerce could foresee that a consumer would misuse a product or use it in a way that they didn't intend it to be used, they still have to warn that consumer against the risk of misusing it in a certain way. So under California law, a product can be found to be defective simply because the manufacturer or any company in the chain of commerce didn't sufficiently warn. And that's the key in these types of claims where the main allegation is the product failed to properly warn the consumer about the dangerousness of the product. That warning has to be reasonable and alert the consumer about the specific dangerousness that product might pose. And it's typically a question of fact that a jury gets to decide as to whether or not that warning was sufficient or not. And oftentimes that involves expert witness testimony, experts in the field of human behaviors and human factors, how normal people behave in when choosing or reading a product label. It also involves very specific factual testimony by the consumer that bought the product and was harmed by the product. So under California law, a company or any company in the chain of custody has a duty to sufficiently warn the consumer of that product about known or foreseeable misuses of that product.
And what if that warning is buried within a 5, 10, 20-page manual, small print?
That again goes to the reasonableness of the warning. If a electric blanket has a risk of catching fire and causing burns or death, and that manufacturer buries that fact in a 100-page booklet in small print, then I would argue strongly that that's not a sufficient or adequate warning. When we're talking about serious injuries like burns or death, that warning has to be front and center in big letters so that the consumer sees it easily and without having to read through a 500-page booklet. So in that specific instance, I believe that would not be a reasonable warning. But again, that is for the fact finder, the jury, or the court to ultimately decide.
And is the consumer expected to read through a manual? Because some of us just open up a product and start using it and ignore the warning contained in a long manual.
So certainly a defendant in a case is going to argue that reasonable people open up a product and read the manual front to back before they start using the product. But a good trial attorney or plaintiff's attorney would likely rebut that argument, but that's not the way normal people behave. And the company knows that. A company knows that most Americans, when they buy a product, open it up and just start using it. So if there's a serious risk of harm that's inherent in that product, a different warning label has to be included with that product. Some sort of sticker on the box, some sort of sticker or pamphlet that's, excuse me, in bright letters that comes at the top of the box when you open it, so that once that person opens that box, that danger or that warning of the inherent danger in the product is right there for everyone to see easily and quickly. So a manufacturer or any company in the chain of custody can't get out of a case simply by saying that the plaintiff should have read the manual. Certainly, a juror, the fact finder in the case, gets to weigh who's at fault for a particular injury. And in California, we have what's called a pure comparative fault system. So a jury would come back in a case like this and say, well, I think the plaintiff was 10% at fault for not reading through the entire manual before using the product. However, I believe the defendant is 90% at fault for not quickly and more readily warning about the serious dangerousness of that product. And in such a case, the plaintiff's award, if any, would be reduced by his or her percentage of fault. In the previous example, a 10%. So if a jury awarded $100,000, that award would be reduced down to $90,000.